Good morning, class. Welcome to what promises to be what I promise to be a very short series of video lectures. I know that might disappoint some of you, particularly maybe you, Pavuti, in the back. However, I think I'm definitely made to deliver these things in person, but with my absence due to this dreams trip, I felt that there was no other way to get this information to you than through this format. So today we're going to talk about a very important topic. It's the rule of law. I know it's one that many of you are familiar with. Many of you did take grade 11 law, so you were taught the basics of this concept and principle at that time. Today I will shed a bit more light on the concept. We'll probably go a little bit deeper into a theoretical perspective. And I will try to relate how this concept is crucial to the survival of democracy and the healthy functioning of democracy. One thing I have to state at this point is that, as you can tell, this format limits me in my ability to be able to deliver information. So please, Hannah, no questions today. Okay? Thank you. Anyway, without further ado, let's get started. The rule of law. So I'm going to begin today's lecture by providing a little bit of a historical context to the rule of law. The rule of law is a fundamental principle of law that has long been connected to the concept of constitutionalism. Now, I know we haven't really taught that as a specific topic here in this class. I did spend an extensive amount of time teaching this to my students in politics. And constitutionalism is quite simply a principle that does date back to hundreds of years in British history, which basically subscribes to the belief that the highest authority in society is the law. So as from that you can derive or you can surmise that there can be no constitutionalism without the rule of law. So these two are in essence kind of married concepts. From that standpoint, the rule of law is the building block upon which all democratic societies are founded. It has been utilized for centuries to provide society with structure and order. And the manner in which it provides that, most simply, can be described as this. It creates a hierarchy in society, and that hierarchy places very clearly the law as the highest authority in society at the top of that pyramid. The true origins of the principle date back to Aristotle. So now we're going back virtually thousands of years. And he was a philosopher who believed that laws were necessary for the governance of society. I mean, that's no startling revelation to us. Although the basic conception or variations thereof were held by many philosophers throughout history, the rule of law, very simply, has gained relevance during the more modern eras of history. Now, when I say modern, I guess I have to put an asterisk around that. I'm going to date us to the 13th century. I don't necessarily consider that to be modern through our viewpoint, but when you look at how long we've been on Earth, it is fairly modern, so to speak. And specifically, the year 1215, this was the year that King John signed the Magna Carta. This was a very important moment in the history of civilized society, but very much so for this concept of the rule of law, because it was a concession that even the king was subject to the law, just like every other citizen was. This was also affirmed not too long after that in the year 1250. It was reaffirmed when a judge during the reign of Henry III, ruled that, quote, the king himself ought to be subject to God and the law because law makes him king. Again, this would be a reaffirmation of the divine right of kings, but it is acknowledging here that even kings must respect the law and are governed by the law. The term rule of law is derived from the French, and pardon my French, pardon that pun, is le principe de l'égalité. And this simply translates literally to mean the principle of legality. Implicit in this is that government is based on principles of law, not of men. In a broad sense, the rule of law means that the law is supreme and above every individual in society. With the rule of law having developed over numerous centuries, it is fair to conclude that it has undergone several changes and adaptations from the time that it was originally conceived. I'm going to focus here on Canada to provide a little bit of that evolution. In Canada, the rule of law has been defined by the Supreme Courts as this, quote, conveying a sense of orderliness, of subjection to known legal rules, and of executive accountability to legal authority. Now, I know that sounds confusing, and perhaps it's intended to sound confusing. It is legalistic, after all. But it is something that does suggest to us that over time, we've come to realize that accountability is important, and accountability is to the law, and most importantly, for those who are in positions of authority. So yes, laws do provide structure and order in society, but they also hold those in power to account. This definition is the culmination of the Supreme Court's interpretation and application of the rule of law over time. Now, I'm going to review very quickly, and again, some law students will recall these better than others, some very important legal decisions, sometimes called landmark decisions, which have come to define exactly what the rule of law means in this country. In 1959, there was the Roncarelli versus Duplessis case. For those who don't know, this is, very quickly, this is when Roncarelli, a bar owner in Quebec, Montreal in particular, I believe, was showing sympathy and support for Jehovah's Witnesses in the province of Quebec and the city of Montreal, much to the dislike and dismay of Premier Duplessis. Duplessis, in response to some of the actions of Roncarelli, phoned a friend, so to speak, in the liquor licensing board in Quebec and advised him that Roncarelli should lose his liquor license to operate his bar. Well, this became a legal issue. Obviously, it was challenged in court. And really what's at issue here is Duplessis, the premier, a position of supreme power in the province, is he able to exercise his authority to exact some sort of punitive action on Roncarelli for doing something that Roncarelli believed was not illegal, and he was following his moral compass, so to speak. Anyway, it was determined after this case, because Roncarelli does win his case, that all official government acts must be authorized by law. So we can't simply phone a friend, grease somebody or twist a few arms to make things happen in a manner in which that leaders like to see happen. And perhaps our friend Donald Trump south of the border should review this case to take a few lessons from it. Another case in 1985, there was a reference to Manitoba's language rights. Now again, just to give you a little bit of heads up, some of you might not be aware, the Supreme Court of Canada does hear cases. It's the highest court of appeal in the country. However, matters of law can be referred to the Supreme Court. Governments do this when they require greater clarity on legal decisions and legal matters, and it's kind of intended to provide a guide moving forward for the government to act. So in this reference, it was established that the rule of law requires the creation and maintenance of positive laws, which preserve and embody the principles of normative order. And these principles of normative order are basically appropriate rules and standards of society. Now, what do we derive from this? I think what's important to take from this is the fact that the Supreme Court has acknowledged here that law and order and the rule of law itself is contingent upon governments passing laws. As it says right here, the rule of law requires the creation and maintenance of positive laws. Those are human-made laws, okay, which preserve and embody the principles of normative order, which are the standards of society we wish to uphold. So kind of dating back to some of the stuff that we've taught you already about natural law and positive law. We know that natural law, kind of guided by morality and some higher order, does serve as the basis of many of our natural rights. However, positive laws are required in order to be able to uphold these natural rights. And I think this acknowledgement here in this reference is that the rule of law does depend very, very heavily on these rules that are created by government. The third case I'm going to provide for you is another judicial reference. It's from 1997 to 98. There was a few cases here that were involved. And this is one that it was determined by the Supreme Court that the requirement that the exercise of all public power must find its ultimate source in a legal rule. So taken together, when you take the rulings of the Supreme Court in these three particular cases we've identified, the rule of law doctrine basically stipulates this. So treat this like a formula. Those three cases are things we're adding together, and this is what comes after the equal sign. It stipulates that the relationship between the state and the individual must be regulated by law. As it says here, quote, a principle of profound constitutional and political significance. Okay? So I think from this historical context, what we do understand is that the rule of law is a very important principle. It is clearly one that we hold dear to us here in Canada to uphold our democracy. But as the Supreme Court has reaffirmed, it has profound constitutional and political significance. So again, going back to my original point, you can't really separate the rule of law from constitutionalism. They're dependent upon each other. Okay, next, I want to talk to you about how it works, so to speak. Now, the rule of law is intended to be a safeguard against arbitrary actions of government and/or its authorities. This is, I think, the way it was taught to you in grade 11. And again, this is where I think your understanding will become clearer now of this concept. To be effective, the rule of law requires not only the submission of all to the law, but also the separation of powers within the state. Let's think back to civics. Perhaps, I know I taught this in the politics class, and you might recall this from grade 11 law, what the separation of powers are. In Canada, there are three separate branches of government, as there are in most democracies. We've got the executive branch, which kind of administers the law. We've got the legislative branch, which makes the law. And we also have the judicial branch, which enforces the law and upholds the law and the Constitution. The rule of law, again, just to reiterate, suggests that it is very important that there be this clear separation of powers within the state in order for the rule of law to be effective. Now, since the law is the primary mechanism for checking government powers, there must be a separation among them, and this is how this separation works. Those who make the law, those who interpret and apply the law, and those who enforce the law. I've just suggested to you which branch is in charge of what, but those three matters of law, those three clear separations of law have to exist. Hence, I hope you can see this now and identify why this is so important, the need for an independent judiciary. There are three key elements to the rule of law, and I know this will be review for you. Number one, individuals must recognize and accept the need for laws to regulate society. We, as Canadians, are considered to be upholders of the law. We respect the law. We see very little protest, uprising against the law because we recognize its importance in upholding a civilized society. Recognition that the law is supreme over acts of both government and private persons is clearly evident here in this first element, okay, of the rule of law. The second element is that all people are equal under the law, and therefore no one is above the law. This is true regardless of position or rank in society. No one is exempt from the law. The third element is that no action can be taken unless authorized by the law. Now, this is where the courts become very important. The courts are charged with ensuring everyone is accountable to the law, and legal rules must be enforced by the courts. It is the courts who are given this jurisdiction and this authority. Individual rights may only be taken away in accordance with the law, as stated directly right in our Charter of Rights and Freedoms. So these are the three key elements, again, to review. The recognition of the need for laws, the fact that the laws apply to everybody and no one is above them, and finally that any action which is to be taken, okay, that would restrict one's rights must be done in accordance with the law, i.e. through the courts. So the final part of this short but pleasant lecture is the rule of law and its significance. Now, I know some of this has already become evident through this lecture, but I will just try to wrap things up here very quickly to make it very clear to you. From an obvious standpoint, the rule of law is significant because it governs how individuals live together in society. We live in a great country, and one of the reasons we do, amongst many other things, is the rule of law, our recognition of the need for laws and our respect for it. The basic expectation is that we want to be free from harm and treated fairly. We are witness to many things in this world, and you could argue that our respect for the rule of law is illuminated from our discomfort when we look at places throughout the world that have no respect for the rule of law or operate outside of the rule of law. I mean, you could look at North Korea, you could look at what's happening in Syria today. There are many places in the world which serve as good examples of societies that have no respect for the rule of law, and we see how that unfortunately bears the price on the citizens of the state. As citizens who benefit from all that democracy has to offer, we clearly recognize the important role the Constitution plays in our lives. The Constitution, again, implicitly demonstrates our respect for the rule of law by the mere fact that it is the supreme law of the land. We know, and we constantly reference law, obviously in this course and in many courses that we teach, but nothing can be higher than the Constitution as the law in terms of being the law of the land. There is no rule of law without a constitution, and there can be no constitution without the rule of law. I hope this lecture has made that very clear to you. And I'll conclude by simply saying this. The rule of law is what permits democracy to flourish in places like Canada and provide us with the life that we have here. Thank you, guys. I hope you enjoyed that lecture. If you have any questions, you might direct them to the supply teacher if they are comfortable answering them, or you'll just have to reserve those questions until I return. Looking forward to seeing you in a few days.